Welcome to Riding Counsel with Rich Jaffe, where the open road meets expert advice. I'm Richard Jaffe, an attorney and biking enthusiast, and this is the podcast where we dive into the world of motorcycling, safety, culture, charitable giving, and riding right. So, whether you're a seasoned rider or just getting started, let's talk bikes, the road, and everything in between. Let's ride! What's up, everybody? In ridingcounsel.com land. I have a great show for you today. I'm going to tell you a little bit about it. What if I told you that the biggest threat to an injured motorcycle isn't the crash, it's what happens after the crash? Insurance companies hire lawyers whose job is not to find the truth, but to erase your case. Today's guest knows every trick in the playbook because he's used to be one of them. And he's defended negligent drivers, minimized motorcycle injuries, and helped insurance companies pay riders as little as possible. But now he switched over to the right side, and I'm very thankful to have him as a guest on the show so he could tell you all about it. Today, we're pulling back the curtain on this, okay? And if you ride, or if you love somebody who rides, this is the episode the defense never wanted you to hear. I have some great information for you, but before I start, I want to first thank you for coming on. Thank you for listening. Thank you for watching. And do me a favor, hit the like, subscribe, share. It really helps me out. You can always find me at ridingcounsel.com. I am Rich Jaffe. I am a motorcycle enthusiast. I am a podcaster, and I'm a personal injury attorney handling motorcycle accident cases. And today I have another lawyer with me, and his name is Garrett. Garrett, how you doing? Thanks so much for coming on the show. Garrett, tell me about who you are, where you did it, what do you do? Give me the 411, man.
Hi, Rich. Thanks for having me. I am a plaintiff's attorney now, after years and years of working for defense firms, working for the carriers, really working for the insurance carriers. I got really tired of them screwing people over. Like you had put it, minimizing cases, trying to pay people the least possible on really valid claims. And as you know, especially in motorcycle cases, you deal with grievous injuries a lot of the time. They do whatever they can to kind of chop that out from under people.
Yeah, it's a game to them. It's a game to them. Certainly not a game to the person who's hurt as a result of a motorcycle accident. Certainly not a game to us. But you're working for the right side now, and that's really what counts. But I appreciate your knowledge on this because you used to work for the defense side, and I wanted to get into some issues that how the defense actually approaches this stuff. So a defense lawyer, they'll get a motorcycle accident case handed to them, and they have to defend it and really try to minimize the case. But what's like the very first thing defense lawyers look for when they see a motorcycle case?
We're looking for comparative negligence, really. Anything to put even just 1% on motorcycle rider, anything that we could possibly argue in terms of lane positioning or anything like that, just to shift the buck, pass the buck, shift the blame immediately. That's usually the first step.
Yeah, so I'm sure that comes into play with jurors a lot. Now, when we're talking about jurors, how often do defense lawyers assume that jurors don't like motorcyclists?
Pretty much all of the time.
Why is that?
I think there's bias. We've all seen motorcyclists, go between cars, here and there. But I think when it comes to motorcycle claims, there's just these built up stereotypes for motorcycle riders that the insurance companies totally rely on in terms of, they assume that you're doing something unsafe while you're on your motorcycle. And that, I think they really lean on the fact that jurors are going to feed into these preconceived notions, even just from, the media, movies you've seen along the way, that somehow it's on the motorcyclist to, that they cause this accident themselves, that they're their own worst enemy, that they're the perpetrator here.
A lot of times what I see when handling motorcycle accident cases is there's no proof that the motorcyclist was speeding, but the defendants always argue that the motorcyclist was speeding. And I I don't know why. I mean, it's just a silly thing, but why do defense lawyers do that?
I think again, it's just based on biases and the media. To be honest with you, again, movies, TV shows, things like that. But also, I think if you can start planting seeds on the defense side that the motorcyclist was speeding, right? Um, from the outset, I just think it's believable, to be honest with you, for jurors based on these preconceived notions. Even though motorcycle riders ride and follow the laws just like everyone riding a car does, and I think even more than that, I think we all see bad actors when we're driving cars, driving other cars, right? People who speed past, ride up the shoulder, do unsafe things in a car. And I think for whatever reason, the insurance company relies on the fact that if you've ever seen someone on a motorcycle do something unsafe, that's kind of the bias that's sticking in your head also for some reason. I think it's an unfair bias, to be honest with you, but I think you kind of remember more things you see involving a motorcycle because it's not as common, to be honest with you. You see all these cars driving past you all the time. You're not remembering, you're not internalizing all these things that these unsafe drivers driving cars are doing. But if you've ever seen a motorcyclist do anything unsafe, you're like, yep, that one time. I think that really plays with jurors.
Yeah, yeah, I tend to agree. And where I also see that a lot is motorcycle helmets. Now, motorcycle helmets, at least in New York, are required. But some states like Florida, they're not so required. But to me, it's almost like you're screwed if you wear a helmet and you're trying to argue that in court, and you're screwed if you don't. And, defense counsel sometimes twists that stuff up. And how is it that you've seen your defense counsel buddies try to use wearing a helmet or not wearing a helmet against the motorcycle rider?
Right. Well, it is a damned if you do, damned if you don't sort of situation, because if you're wearing a helmet, the argument is, oh, how bad could those injuries have been, right? He's wearing a helmet, right? He's protected. But on the other side, if he's not wearing a helmet, they would use it to say, this is someone who has shirked responsibility. They're doing an unsafe thing. They're riding without a helmet to begin with. They don't have any regard for the rules or for their own safety. So it's, there is no win there, to be honest with you.
Yeah, yeah. So it's just portraying the motorcyclist in a way that jurors really are not going to like. I guess that goes also with medical records. They really try to get medical records that defendants really aren't entitled to. Somebody's in a car in a motorcycle accident, and since that date, they're hurt. But I see defense counsel always trying to get prior medical records. Why is that?
I think they assume that there must have been some other accident, right? They try to blame it on either pre-existing conditions instead of the crash itself, or I think there's this assumption that motorcyclists, or motorcycles in general, they're less safe, so there must have been some pre-existing injury from some prior accident. Something else has happened along the way, so they can immediately start blaming it on the old injury or pre-existing condition.
Yeah, and I see that a lot. And what I also see on YouTube and social media are these little films of motorcyclists all over the place. But what I've also seen defense counsel do is send out investigators to try to get some surveillance on the person who's injured in a motorcycle accident. Tell us what's that all about?
Well, I think they send out these investigators to do surveillance. They're desperately hoping for some smoking gun, right? They're going to find you dunking a basketball or doing something crazy. But I mean, I think ultimately what they're really trying to do is catch you doing anything that can be argued against the severity of your injuries, right? So that you had one good day, you posed for a photo op, you went to the store, you've had one good day, and somehow that erases the months, if not years, of pain and suffering that you've gone through from this injury. They try to catch you that one little snapshot and say, look, he's doing just fine.
I find defendants always they try to get this stuff in front of a judge or whoever else will listen really early on in a case, or maybe even at a deposition, even way before the trial. Why is it they're always trying to just pile it on in more of the beginning of the case?
I think it all goes back to those biases in terms of, how they're going to think that a juror is going to look at a motorcycle inherently. I think that applies to a judge or even an arbitrator as well. I think the sooner they can get in front of that trier of fact, they think the better off they are because of those biases.
So let's talk about something that I've also seen brought up a lot, and it's something called assumption of the risk. What happens a lot of times is that somebody will assume the risk of something, maybe something like, they'll say riding a motorcycle is something that's inherently dangerous. So what they do is they get on the motorcycle and, they're assuming the fact that riding a motorcycle is really something that's dangerous in and of itself. How do defense counsel actually try to use that?
So defense attorneys will argue that assumption of the risk is the same thing as basically consenting to being involved in an accident, right? To being consented to being hit, to have, someone else's act, that it was almost foreseeable just because they got on a bike, that it was inherent to what, the activity that they were doing in the first place.
Right. Yeah. I think they really try to mix that up. Riding a motorcycle doesn't necessarily mean that you're consenting to being hit by a car. That's not really right. Those two things don't make sense. But I guess what happens is defense counsel tries to mix those two up so the jurors are a little confused and they don't come out with the right result. I also see a lot of times where these cars are in an accident with a motorcyclist, and the motorcycle itself might be damaged, but the car itself, there's really not too much damage there. How does that play into how jurors might see an accident?
Well, it's one more way for the defense counsel to minimize the injuries of the motorcyclist, right? And I think a lot of the time when people think of a bad accident, they think of smashed up vehicles, specifically two smashed up cars, but it's obviously going to be different when it involves a motorcycle, right? Sure, the bike might take the brunt of the hit or might take some damage, but your body's there. Your body is exposed, right? So I think it's used to kind of mislead jurors and say, how bad of an accident could this have been? Look, there's a scratch on the car, right? There's a scratch on the truck, but it's not taking into account what's happened to this individual's body who is riding the motorcycle.
Yeah, and I think that's why, motorcyclists really have to wear a lot of protective gear because they are exposed. But I see a lot of defense lawyers really concentrate on what a biker was wearing at the time of the accident. Why do they do that kind of stuff?
I think there's a couple of reasons there. So first, I think one of the reasons in terms of arguing liability, they might use it to argue visibility. But realistically, if a driver hits a motorcyclist, it's on the driver, right? They still should have seen what there was to be seen. So I think on some level it's visibility, but I also think it goes back to that assumption of the risk. I think it's, whether or not they were wearing protective gear. If they weren't, it goes back to what we were talking about before with the helmet, right? If they were wearing the protective gear, how hurt can they be? If they weren't wearing the protective gear, this is a reckless individual, who got themselves into trouble here.
So one of the things that I always suggest to my clients whenever they're in a motor vehicle accident or a motorcycle accident is I always tell them, stay off social media. Don't post to your friends. Don't post to your family. Don't post anything, because really I feel like that can backfire. Have you seen any cases or handled any cases when you were a defense lawyer where you might have seen something on social media that really blew up the case?
Yeah, absolutely. I mean, specifically with someone posting something, as against maybe the limitations that they had said they had. But, I think it also goes back to the same point we made when we were talking about surveillance a minute ago, right? It can blow up a case because if you say you couldn't do something or something impacted you, right? All of a sudden, they say, oh, you're caught in this lie, right? Here, he said he couldn't ride at all. Here he is sitting on a bike. But in the context of it, maybe he was sitting for a photo op, right? Maybe he was just taking a picture with his riding buddies. There's context for everything. But if that picture gets in front of a jury, who's gonna listen to the argument that it's the context? Again, these biases are all gonna play into effect again.
That's what happens. It's they post things on the internet, and they'll say one thing, and then like, I can't go motorcycle riding anymore, and all of a sudden they'll see a picture of that person on a motorcycle, or they'll say, okay, well, I can't go out with my friends, and then all of a sudden there's a picture with their friends. So I see that a lot on social media, and I'm confronted with that kind of thing. And when I'm confronted, it's a really hard argument to make against it. So I imagine that defense counsel does that all the time.
Yes, definitely.
So, another thing that I see a lot is when defense counsel, after somebody's hurt like this, they send them to something known as an independent medical examination, and I always kind of laugh at this, and I see you're kind of giggling, but tell me, is this really an independent medical examination that the insurance companies send injured riders to?
No, it's not. It's paid for by the insurance company, right? The insurance company, it's a panel of doctors that the insurance company sends hurt individuals to. And realistically, on some level, they know that if they don't write the report the right way, they're probably not going to be on that panel for long, right? So the fact that they call it an independent medical examination is what I was kind of chuckling at, right? We all know it's a defendant's medical examination.
Right.
So, I mean, really, the whole point of it is just to minimize injuries and write it up the right way so that the insurance company and so that defense counsel can have the talking points and the arguments that they need to make.
What I also see is, unfortunately, a lot of motorcycle accident victims give me a call, but they don't give me a call right after the accident. They'll give me a call a few months down the road, maybe a year down the road, when they're trying to litigate this themselves. They're trying to talk to the adjusters themselves. Maybe you could talk a little bit about the advantages and disadvantages of something like that happening.
Well, coming from the defense side, if we saw any significant gap ever, even just for a couple of weeks, the argument always goes back to how hurt can they be, first of all, and is this even caused by the accident that they're claiming it's caused by, right?
Right. So that's about the injuries. What I'm talking about is, motorcyclists riding around and they get into an accident and they decide not to hire a lawyer. And then when they don't hire a lawyer, they try to handle it themselves. And when that happens, then they start getting into trouble, and then they'll call me or something like that a few months or maybe a year down the road after their accident. And I see a lot of problems with that, but I'm wondering if you have, with respect to, how defense counsel might treat it, how insurance adjusters might treat something like that.
I would say, with regard to waiting, they're never going to take the claim seriously.
I think that's probably all the time we're going to have here for this session. There's a lot more secrets out there that I'm willing to share and Garrett's willing to share. And Garrett is now working with me on motorcycle accident cases. So if you ever need to talk to Garrett or talk to me, you can always get me at ridingcounsel.com. That's ridingcounsel.com. I want you to like, I want you to subscribe, I want you to share, please. It's going to help me out, people. So please just smash the like button, share it, and I would love if I got more people to subscribe. And if you want to hear any kind of aspect of motorcycle accident cases from a legal point of view, or maybe you're a charity and you want some airtime, hit me up, give me a call. I'm always reachable. You can call me, text me, email, whatever you want. But until the next episode, I want everybody to ride free, ride safe, and, do so legally. All right, everybody, you take care. Bye-bye.
And that's a wrap for this episode of Riding Counsel with Richard Jaffe. Thanks for tuning in. If you enjoyed the ride, be sure to subscribe, leave a review, and share with your fellow riders. Until next time, keep the rubber side down and ride safe.